Thank you.
SJC-11233, Morse versus Kraft.
Good morning.
Thank you.
Morning, counsel.
Good morning. Daniel Goldberg, representing the plaintiff in this case, Richard Morse, as trustee of the 1982 Kraft Irrevocable Family Trust. With me is Carl Solomon of my office. This case, as the court knows, is here on a reservation and report from the single justice. It raises two issues. The first is whether the terms of the 1982 trust, which allow the trustee the power to distribute directly to beneficiaries and also for their benefit, permits the trustee to also distribute to a trust for the benefit of those same beneficiaries. That's issue number one. Issue number two is to the extent that a guardian ad litem is required for minors or unborn children, whether under various provisions of law that should be waived. My plan is to focus my remarks on the first issue, but before I do, I just want to comment briefly with respect to the jurisdiction of this court, because as the court knows, the defendants in this case, but for the IRS, have assented to the relief, have agreed to the factual statements.
The IRS hasn't said no, has it?
The IRS has not said no, and has
said nothing,
as
correct?
is traditional in this case, and as this court has recognized in prior decisions, it is the practice of the IRS not to appear in these cases.
Right, but we could change our mind.
They could change their mind.
We
They
could
have
change
not.
our mind as to the willingness to do this.
Well, you could, Your Honor, but I will say this, that this question of jurisdiction, which you have addressed in a number of cases, first agricultural case, for example, exactly this situation, a petition for instructions, stipulated facts, all defendants agreed to the relief, and the IRS was served but did not appear. And as the court said in that decision, we have no doubt the circumstances warrant our issuing a declaratory judgment of instructions. Similarly was Fleet versus Marquis, Walker versus Walker. And in that case, Walker versus Walker, which was 2001, this court said it's the longstanding practice of this court to grant the relief when the parties represent that doing so will help them in dealings with the IRS. So, yes, Judge, it would be, I think, a dramatic change in how this court has handled these cases for it to say that somehow the IRS now needs to appear.
Let me ask you this. What evidence, not in this case because it hasn't come to pass yet, but, I mean, can you tell me anything that suggests that the IRS, Bosch, if I recall correctly, was decided in 57, 77? One of those two.
I'll give you that date in.
I should know this, but I forget. 67? I have 7 in my mind, obviously.
1967, Your Honor.
67. Okay. So here it is, almost 45 years later. And what evidence do we have that it is still the case, as far as the IRS is concerned, that they won't follow what another? I mean, this is a pure sort of request for instructions, right?
Yes, declaratory judgment and petition for instructions, both, Your Honor, yes.
Something that is very much probate and family court fare, usually, right? So so in this 45 years, what do we have that says, yes, the IRS is still insisting and will find itself bound by the highest court of the state?
We have a history, Your Honor, of them continuing to do that. That is, I'm not aware of any instance where there has been, including after decisions from this court, that the IRS has come in and taken a different position. And I think significantly, Your Honor, the safe harbor regulation on which we rely and what leads us to this, which is 26 CFR 26.26011B4.
Gotta love it.
And that's the safe harbor which provides when the retention of the trust's exempt status continues in the case of a modification of the trust. That regulation specifically states that the exempt status will continue if the terms of the governing instrument of the exempt trust authorize the distribution of a new trust without the consent, approval of any beneficiary or court. That is, that's the regulation that gives us the safe harbor. That regulation was adopted by the IRS in 2004.
Yeah.
And it is that regulation, obviously much more recent than the Bosch case, but it is that regulation which shows that the IRS continues to focus on this issue about the GST exemption. And and that's why, given Bosch, we need a decision from this court. And the state of the law, Your Honor, is such that, as the papers make it clear, the trustee will not do the decanting without the decision of this court, because the risk of losing that GST exemption is too great. GST taxes are now 40%. So if the trustee were to take the action that, as set forth in the papers, he believes that it is his fiduciary duty to do it.
My question was really, and I didn't express it very well, but I mean, I think you'd give me the same answer. It wasn't so much whether the GST, it wasn't on the substance. That is, do you need a court to tell you you can do this? It was more on, do you need this court as opposed to the probate and family court?
I know of no decision from any federal court, including obviously the Supreme Court would be the one applicable here, which raises any questions about the continuing application of Bosch. And so far as we are aware, it is something that the IRS continues to follow.
Can I ask you, on a substantive point, that the one thing that concerns me a bit is this. You say that the trustee here has essentially the inherent power, and there's nothing specific in the trust about the trustee taking all of this money and transferring it to new trusts, right?
That's correct.
So you're saying it's inherent in the way this is drafted that he can do that?
Well, we actually are a little bit more specific than that, Your Honor. The amicus brief takes the position that this is the inherent power of a trustee. Our trust, though, and we think for reasons that are stated in the amicus brief, their position makes a lot of sense. We don't need to go that far, because under the language of our trust, it says specifically whenever the trust says a distribution can be made to a beneficiary, that should be interpreted to include a distribution for the benefit of the beneficiary.
Right, so I do understand that. So let's say, but only a disinterested trustee can make these distribution decisions. The 1982 trust, as a disinterested person, has to make the decisions about distributions, right?
Has to make the decisions about distributions, yes, because otherwise, and this is one of the reasons, another one of the reasons for the amendment. Right now, the 82 trust does not provide what the IRS refers to as an ascertainable standard. So if one of the sons were to be a trustee and were to distribute to himself, he'd lose the benefit of the GST because he's not subject to an ascertainable standard.
All right, so let's assume that this disinterested trustee, 3 years after the trust is set up, decides to distribute all of the money to these new set of trusts in which the beneficiaries actually will have the power over distributions.
Yes.
That wouldn't be a fundamental violation of the purpose of the trust in the first instance? Now, we're talking 40 years later, but what if it were to be 3 years later?
Well, whenever the trustee acts, the trustee is subject to several things. Number one, most importantly, the subject as trustee is subject to the trustee's fiduciary duty. The trustee can't do these things willy-nilly. And secondly, the trustee has to act consistent with the trust document because that trust document reflects the intention of the donor.
But you're saying he's acting now, he's doing exactly now what I suggested.
Yes, he would like to
Do
do
in
exactly now.
1985.
He would like to do that now.
Why would this be improper in 1985 but okay now?
Oh, I don't think necessarily would have been improper in 1985.
Okay.
But it's a question of looking at what the circumstances were then, looking at his fiduciary duty, and looking at the intent of the donor. So our position in terms of and all we're looking for from this court is a statement that the trustee has the authority to do it. We're not asking for this court to look at the fiduciary situation and say, yes, we bless him doing it. All we're asking this court for is an interpretation of the 1982 trust, which indicates that under the language of that trust, the trustee can distribute not only directly to the beneficiaries, but to a trust for the benefit of the beneficiaries. If we get the authority from this court, then the trustee will have to look at the situation as it then exists and decide, whether his fiduciary duty then warrants taking that action. As we've described in the papers, when the papers were filed, he sets forth the reasons for doing that. But we're not asking this court to bless him specifically following that action. We're not looking for this court to bless the form of the new trust that's attached or the like. We're just looking for a decision that he has the authority and has had the authority since 1982. So I mentioned in responding to Justice Cordy the language for the benefit of. Beyond that language, there is also very broad language which if the court didn't deem that to be an explicit authorization to decant to a trust, to distribute to a trust, the 1982 trust also has language with respect to the powers of the trustee, extremely broad powers. That's in Article 7. The trustee shall have full power to take any steps and do any acts which they deem necessary or proper in connection with the disposition of the property. So we say, look at the language of the trust, both in terms of using the language for the benefit of, and a trust for those beneficiaries is obviously for the benefit of those beneficiaries. We say, look at the language of the broad power of the trust. We say, look at the cases that have looked at this issue in other jurisdictions. We have found only 2 states where the highest court has addressed, or indeed any court, has addressed this issue. In both those cases, in New Jersey, in the Meadham-Meyer case, these are both in our brief, and in Florida, in the Phipps case, the court has said, yes, the decanting authority that we're looking for is a part of the trust. A trustee is authorized to do that, even though it doesn't explicitly say you can distribute to a trust. No case in this country has gone the other way, looking at that issue.
Can I ask you, this is following up on Justice Cordy's question. So let's assume you can, or the trustee can do what it is that he would like to do. And these new trusts are set up. And the sons become trustees of those, is that correct?
That certainly is the possibility that we want to open the door to.
But you don't need us to bless that,
No.
correct? Okay.
No.
So, but if the sons become the trustees, I'm just interested in this. Well, I guess whether it does or doesn't satisfy generation skipping tax isn't my problem. But I guess my question then is, in terms, this goes to the guardian ad litem. Mm-hmm. If the son becomes the trustee, why is there not an issue, at least theoretically, and I'm not impugning any one of the 4 Kraft sons, but just theoretically, would there not be an issue in terms of guardian ad litem that the grandchildren are losing some protection of a disinterested person making decisions about where the money where it should go, in other words, to their father or be saved for them? Do you see what?
I think I understand the question that you're posing. That is there somehow a conflict? Because
there may not be, but it just sort of goes to whether we do or don't need a guardian ad litem for them.
Well, I think on the guardian ad litem, Your Honor, there are actually three statutory bases that this court would have to waive the guardian ad litem. The first is under 190B, Section 1-108B, and this we explain in our brief. This deals with the question about whether the class of persons subject to the special power of appointment in the trust is narrower than the class of persons to whom the trustee can distribute. I think I've stated that correctly. And when that is the case, which is the case here for reasons explained in our brief, then under that statutory provision, the holder of that special power of appointment, which in this case is the four sons, has authority to represent the minor and unborn beneficiaries. In addition to that provision, there's 190B, Section 1-403(2), double I in the whole, where the son can represent the minors because we don't see that there is a conflict, because the son, each of the grandchildren is the issue of a son.
Right.
And so the distributive power, that we don't see a conflict between the son and the grandchildren, and therefore under that provision as well. And under the new Massachusetts Uniform Trust Code, there are two provisions.
Isn't 190B the new trust code?
203E,
Oh, okay.
303(6), where opening the door to a parent representing a minor and an unborn child, we think that would also apply, and 203E 304.
If we didn't agree with you on that point, does it create a problem for you?
Well, it doesn't create a problem in terms of the ultimate relief, but it depends, I guess, what the court does with that issue. That is, will we need to be back again if a GAL needs to be appointed, have the GAL weigh in on the issues, and then come back and present the matter again.
I'm curious, because we have said repeatedly that GALs are pretty important in cases like this. So I'm curious as to why you wouldn't have proceeded that way to begin with.
Well, I think it was in part, Your Honor, a question of time. We have an interest in trying to this is all part of
Is that because
estate
Mr.
planning
Ehrlich
efforts.
wants to relieve himself of it? I mean, this is time to move on.
He's in, as explained in the papers, he's in his 80s. He's been the disinterested trustee from the outset. He's gotten to the point of looking at the situation where the sons are now in their 40s, and frankly, with the new Uniform Trust Code, looks at provisions in the Uniform Trust Code, and there are things now which ought to be incorporated in a new trust. And we just did not see any conflict between the sons and the grandchildren, and given that and the various provisions which allow the waiver of the GAL, felt that this was an appropriate case for waiver.
Now, your time is over, but if you'd like to conclude with some final remarks, you may.
Well, on the base, thank you, Your Honor. On the basic issue, as I indicated, we think it's clear in the language. If it were 100% clear and said could distribute to a trust, we wouldn't have had to file the case. But we think beyond that, it's clear in the language. We think it's clear in the case law, and we think it's clear in the public policy reflected, including in the new MUTC, that this kind of decanting is consistent with public policy. Thank you,
sir. Thank you.